Well, with 2019 now in the books, we reflect on a year full of legal and tax developments impacting ag producers across the country. And we continue our countdown of the top 10 issues in today's Rural Money segment. Joining us now is Roger McEowen with the Washburn University School of Law. Thanks for joining us, Roger. Happy to continue our countdown. 2019 saw its fair share of water regulation issues. And number 8 on your list is a case involving groundwater discharges and WOTUS. Let's start with the recap there.
That's right, Christina, and I would venture to guess that in 2020, this is going to be even higher on my list of top 10. It's at number 8 because the U.S. Supreme Court has agreed to hear a case coming from one of the circuit courts of appeal to clear up disagreements that the circuit courts have on this particular issue. And the issue is whether a farmer, for example, would have to have a federal Clean Water Act pollution discharge permit if the discharge first goes into groundwater and then seeps into a water of the United States. Under the Clean Water Act, groundwater is exempt. But if it first goes into groundwater and then finds its way into a WOTUS, the circuit courts of appeal are split on that. And in 2019, the U.S. Supreme Court agreed to hear a case from the Ninth Circuit to hopefully clear this issue up, and hopefully they'll do so in a manner that's favorable to agriculture, because it is a huge issue when you think about all of that land, particularly in the Midwest and the eastern two-thirds of the Corn Belt, that is planted on fields that have field tile drainage systems. Those systems would make it easier for so-called pollutants to enter into a WOTUS, and they're very prevalent out there. So we're going to have to see what the Supreme Court says on this. This is going to be a big case in 2020.
Well, we look forward to you keeping us on board with what's happening there. Let's move to number 7 on your list. It revolves around taking private property. Let's talk about that, how it impacts the regulatory takings of 2019.
Right. This is another U.S. Supreme Court development in 2019. They did take a case and rendered a decision in June this past term where the issue was not so much an outright taking of property, and we're pretty familiar when that happens. The government comes and takes some of your land, and they have to pay you compensation for it under the Constitution. Those are the easy cases. The tough ones are when the government regulates your property in such a manner that you lose your use of it. That can be a taking, but they can also be very difficult to prove that a taking has occurred, and the analysis in those cases gets very difficult. What the Supreme Court dealt with in this case in 2019 was whether, or in the event you have a state-level regulatory taking, do you first have to exhaust your any state remedies that you have before you have the right to file in federal court for takings? The Supreme Court had said previously back in the 1980s that the answer to that was yes. You have no remedy at the federal level until you exhaust remedies at the state. They reversed course on that in 2019, and they said, nope, the taking occurs at the time the regulatory action takes place. That gives you right to constitutional compensation at that point in time. That is a big win for farmers and ranchers and other rural landowners that are impacted by state and local regs in terms of land use. That's development number 7 in 2019.
I can't wait to see what number 6 is. Roger McEowen with the Washburn University School of Law. Thank you so much for joining us. Always appreciate your insight, and stay with us.